Good evening, distinguished members of the College of Arbitrators of Nigeria, esteemed guests, dear colleagues. You're all welcome to today's seminar, which is the fourth series in the series of the College of Arbitrators seminar. It is my honor and privilege to serve as your own anchor for this highly anticipated end-of-year seminar and dinner. My name is Hawa Kaka Osman, and I am the college secretary. I'll start by establishing the protocol, and then after then, we'll take the opening prayer, which is the national anthem. Mr. President, College of Arbitrators of Nigeria, Mr. Vice President, College of Arbitration of Nigeria, learned senior advocates, senior members of the college, and our distinguished guests. Today's event is an opportunity to engage in a thought-provoking discussions that shape arbitration practice in Nigeria and beyond. And may I please ask everyone to rise for the national anthem. Can we have the national anthem? Our own dear native land. May tribe and tongue may differ, in brotherhood we stand. Nigerians all and proud to serve our sovereign motherland. Our flag shall be a symbol that truth and justice reign. In peace or battle honored, and this we count as gain. To hang on to our children a banner without stain. O God of all creation, grant this our one request. Help us to build a nation where no man is oppressed. And so with peace and plenty, Nigeria may be blessed. Amen. Thank you, everyone. You may have your seats. The theme of today's seminar is misconduct, a relevant factor in public policy arbitration. This theme is essentially important as it delves into the evolving interplay between misconduct, public policy, and arbitration. For people who are familiar with the College of Arbitrators, one thing is guaranteed, which is value for your time and quality discussions. Ladies and gentlemen, it is my distinct pleasure to introduce you to the panelists for today's seminar. Our panelists are highly respected members of the college with extensive experience in arbitration and have contributed significantly to the advancement of arbitration in Nigeria. I'll start by introducing our moderator, who will moderate the insightful discussion. And we're privileged to have none other than the President of the College of Arbitrators, Chief Patrick Ikweto, Senior Advocate of Nigeria. He has been a driving force behind the college's growth and staunch advocate for arbitration excellence in Nigeria. His leadership and expertise make him the perfect moderator for today's seminar. I will also introduce our next panelist. Can we confirm that the people online are following us, please? All right, thank you. Our first panelist is Mr. Israel Usman. He is a highly respected member of the college with extensive experience in arbitration and has contributed significantly to the advancement of arbitration in Nigeria. We are honored to have him on the panel today. Ladies and gentlemen, we will welcome Mr. Israel Usman. Thank you, sir. Our next panelist is none other than our Vice President of the College of Arbitrators, Nigeria. He is a seasoned arbitrator and a legal expert with remarkable track record of resolving complex disputes. He has been instrumental in promoting the use of arbitration and alternative dispute resolution mechanisms in Nigeria. His insights will undoubtedly enrich the discussion today. Ladies and gentlemen, join me as I welcome Dr. Oke Akobundu. Thank you, sir. And without wasting your time, I will yield the microphone to the moderator, who will ably lead the discussion. Mr. President, sir, thank you.
Thank you very, very much. Good evening, everyone who is here. I'd like to particularly welcome the discussants, and I'm sure we will all be enriched by listening to them. The topic is, as rightly put up by the compare with our secretary, misconduct a relevant factor for public policy in arbitration. We're all familiar with the fact that at the tail end of the last civilian administration of General Muhammad Buhari, he signed into law the Arbitration and Mediation Act 2023. That act has been hailed as being innovative, as having broken the trail that had existed before. As we do know, before that act came into force, we had the Arbitration and Conciliation Act. One of the significant features of this new act is that for setting aside of awards, the ground usually, or ground commonly known as misconduct, is now no longer a ground under the new act, unlike what it was in the old act. So industry users, practitioners, the public are concerned whether misconduct is still a relevant factor in setting aside arbitral award. And to begin this discussion, I will invite Dr. Akobundu to give us an insight by what he understands as misconduct in arbitration.
Thank you, moderator. To kickstart this talk, I'd like to first say that let us go into definitions. Like he has said, misconduct has a definition in case law and has always been. Even while it was at ACA, it wasn't defined so copiously. It always meant it was inexhaustible. Now, to give an idea of what misconduct is, I just made a small note here. I just want to read out something very small to encapsulate it. In the case of Globe Motors against Wester, Obuinya JCA, as he then was, now JSA, just said they said misconduct denotes mishandling of an arbitration as is likely to amount to some substantial miscarriage of justice. Furthermore, it said misconduct denotes a dereliction of duty, unlawful and an improper behavior. It says further that serious misconduct or gross misconduct denotes serious dereliction of duty on the part of the arbitrator. It can be put as follows. It is different from negligence or carelessness. Let us be careful about it. However, gross negligence or carelessness may be, to be guilty of misconduct, it will be willful. The person concerned must appreciate that he is acting wrongfully or is unlawfully committing an act and yet persists in so doing. Like we said, case by case, the judges keep expanding what it means by misconduct, but word by word, we can pick a few words. We can pick a word like non-disclosure, which is a very fundamental aspect of arbitration. We can pick a word like fraud, when a process is tainted by fraud. So it is not exhaustible, but case by case, you can determine what has happened to amount to misconduct, so long as it goes ultimately to affect the justice of the reference or the arbitration. I'll stop there.
All right. Thank you for your very useful intervention. Like we've had what Mr. to you, Mr. Israel Usman. Now that the word misconduct is no longer there in the new act as a ground for setting aside an arbitral award, do you think that the case law on misconduct are still relevant in our jurisprudence today?
Thank you, Mr. Moderator. Misconduct actually, before the new act, was used in two contexts. One has to do with setting aside a award. The other one has to do with... Can you hear me? Okay. One has to do with removing an arbitrator in the course of arbitration. Now, even that one has been removed. The word misconduct has been removed. After removing it, we still have other grounds. There's the one they call public policy. I can, in a sense, maybe understand why the word misconduct was removed, because it was also causing problems. It lacked, thank you, it lacked the kind of definitive principles that could be used. So at the end of the day, it could be removed. However, words like public policy that came in were also not defined. Public policy in relation to what? And what then is the context in which it can be used? So to answer the question, if the word misconduct has been removed, but there are still grounds for setting aside the award, unless I missed something in your question.
So what misconduct from the act as a ground for setting aside an award? Now, and then I asked you whether the case law on misconduct is still applicable in our jurisprudence today.
Okay.
Because you know that cases like Taylor Woodrow, all of these cases setting aside on ground of misconduct, and did give instances of what can amount to misconduct. Say that in any of such instances, an award may be set aside. So now that that ground specifically is no longer part of our act or law, do you think that there's any window to bring any of those instances to play in setting aside proceedings?
Okay. It's somehow a difficult question to answer until we have a definitive decision by the courts. Now, the concept of misconduct can be procedural, for example, and that procedure can be from the agreement of the parties, it could be from the rules of arbitration, it could be from anything. If an arbitrator breaches the rules by which he's supposed to manage the arbitration, that's misconduct. Now, we may not be able to use the word misconduct anymore, but because breach of those rules will affect the arbitration itself, even the valid arbitration, those cases will still apply. There's a new phrase called public policy, which also appears, which even though lacks definition, but will seem to suggest that it's not all about misconduct, in the sense that public policy might actually be a stronger ground than the word misconduct. It's also possible that just because the word misconduct is not used for removal, doesn't mean that if satisfied with the conduct of an arbitrator, or his request cannot be, you cannot request his removal or go to court to have him removed. For example, for non-disclosure, like the case of Taylor Woodrow that you mentioned, there's no way, even though it's a misconduct, there's no way something like that to stand. So maybe the word misconduct will not apply, but the same principles that apply to misconduct still applies to setting aside award today.
Thank you. Dr. Kobundu, now he's mentioned a phrase, even though he says it's a new phrase. Now, would you be able to give us an insight into what is meant by public policy in relation to arbitration?
I'll be careful in saying this, knowing that arbitration, as the name implies or as it's defined, is a private litigation. So let's not think it's a contradiction in terms when we bring in the phrase public policy. Public policy, in summary, encapsulates the standards and norms of a society, what guides them to their values, and whatever offends public policy in a particular society as it relates to arbitration is always a ground to set aside an award. I wouldn't go into removal of arbitrator like my learned friend has said. I want to keep my focus on just setting aside the award, which is what I am concentrating on. Now, the Section 55 introduced public policy, removing Section 30 that had misconduct. To my mind, from what I've seen, public policy is a wider net to ensure that the process are done right. All the issues that fall under misconduct offend public policy, and much more, in the sense that with public policy in place now, you drag it. And just like the former law which says it was inexhaustible, the issues and the matters that come under public policy will also be expanded depending on the manner or rather the particular circumstance of the case that is an issue. Now, on that one, I'll say that since public policy is to ensure the public good, in arbitration, which is private, whatever offends, the people who are parties in arbitration and the arbitrator are members of that public and are affected and are concerned about the public good of the environment which they live in. So, going by what the moderator has said, I can say precisely that public policy is a wider net and it will do more good to the arbitral process. Thank you.
Yes, public policy as used in the ancestral model law is something that covers the fundamental principles of law and justice in substantive as well as procedural aspects. Now, if that is so, would you think that even though a misconduct as a term is now absent in the new act here in Nigeria, if Act which fundamental principles of law and justice, either substantively or procedurally, would you think that such an act or such an award obtained or rendered by such an arbitration can be challenged on ground of public policy?
Thank you. Before I answer, I just want to also give a context of policy in agreement with what the Kobundo said. Even though it's not related to setting aside, but if you remember the P&ID case decision, it was a policy decision. It was not really a matter of something wrong with the arbitration. But what the judge said that was on the policy network, it doesn't want the court or the arbitration on public policy. So even though it was not even a matter of conduct of the arbitrator, that's how strong public policy. To also give another example, a court will not close its eyes to an error of law. I mean, anything that's a bit that's sort of obvious. I mean, that it's a legal issue. And let's not forget that the law is also trying to promote the sanctity and what's the word? Solemnity of arbitration as a viable option to litigation, but not to supplant litigation. So in essence, misconduct remains maybe not in words, but also in policy. As a policy, it's much stronger than maybe the word.
Thank you. That he mentioned about the integrity of the process. I'd like to just ask Dr. Kobundo to give us his view, bearing in mind the well-known principle of interpretation, the mischief rule of interpretation. So obviously, it will be taken that the legislator or the legislature had something in mind when it saw the old act and decided to amend the old act, and in place of what was in that act, put other provisions. Now, would you think that despite all we have said, that because as you do know, the duty of the court and indeed the duty of everybody involved in statutory interpretation is to give effect to the intention of the legislature. Would you think that the legislature intended by the mischief rule of interpretation that the principle of setting aside award on ground of misconduct is no longer part of Nigerian law? And if you think so, would it be right to try to circumvent that position by some other means couched as public policy?
Mr. Moderator is trying to take me back to school days. The mischief rule, if I remember correctly, is that there must be a mischief in the law sought to be amended, and that the amendment is set out to cure that mischief. I've read through the AMA 2023. I don't see the mischief that was intended. What I see is just a nomenclature. Maybe they didn't like the word misconduct. And in trying to remove misconduct, they brought in a phrase, like I said, that is more encompassing. There's nothing that will be regarded as misconduct in arbitration that cannot fall into a breach of public policy. That's why I said that let's assume somebody was trying to circumvent a problem, ends up getting into a bigger problem. My take on it is simply that setting aside an award based on public policy now is even simpler. Once you can establish that in this proceeding or in this process or in this reference, the arbitrators did 1, 2, 3, 4. Like there was a fraud. Like we say, non-disclosure in arbitration is very fundamental. You can't be an arbitrator in a matter that your uncle or your sister or your wife's friend is a party without disclosing it. And mind you, the legal base of it says likelihood of bias, not bias. But let the parties decide. And I'll make reference to this. In IBA guidelines on conflict of interest, they have the red, yellow, and mud marks. There are things you don't negotiate. There are disclosures that you must make, and once you make them, the parties decide. There are some, once they come to you, you walk away. So I believe that the word, if it's a problem, we can call it something else. But misconduct is a big part of public policy, and it's still within our laws.
All right, before I, you want to, yes, go on.
Yes, I just want to add to this issue of interpretation. There's still the principle of, there's a long established principle of interpretation that the law does not intend. My argument would be that it would be absurd the current law as not encompassing misconduct, misbehavior, and procedural irregularities on the part of an arbitrator. It will affect the essence of arbitration and integrity of arbitration. So I think it would be absurd. It's against the rule of absurdity to read into it that you can't challenge on ground of misconduct. And if I'm to agree with the use of the word misconduct, therefore, will not be wrong. We can use other phrases and other words, but because the word misconduct is a part of public policy, therefore we can still use the word misconduct.
I don't know whether you are aware that Code Act grounds for setting aside an award include misconduct and also for being contrary to public policy. It's in the old Act. So now, go ahead. Okay. So now, if you have removed one heading as misconduct and retained only one, public policy, it comes back to the question I asked before. Would you be right for you to circumvent the legislation by saying, oh, public policy is encompassing, and therefore act of misconduct is also a breach of public policy?
Mr. Moderator, I don't know why you're introducing public policy to Section 30. Is it written in Section 30 or you're reading into it?
No, the old Act.
Yes, I have it here.
Yeah, but the old Act was also, you also know that under the ancestral
no, fine. If you're going
model
to
law.
are we doing the ancestral, we're doing the law
No,
into the Act?
no, but the old Act was based on the ancestral model law.
I know.
And the ancestral model law recognizes.
Also now, the ancestral model law still recognizes misconduct till today.
So that's the question. The question
well,
then,
yeah.
if we agree that Nigeria recognizes ancestral model law, that AMA is based on the ancestral model law, it will be right for us to see that we can, as it is, throw overboard ancestral model law elements like misconduct, like public policy, and say that our act is all encompassing.
No, I don't know why we're stretching it. The fact is this: the word misconduct was deleted from the Act. The word was not deleted from a lexicon.
Good.
Yes. When you're pushing a matter for setting aside based on public policy, using the word misconduct does not mean introducing the word misconduct into the Act. The arbitrator misconduct himself, you now state the areas of misconduct. Is a word in English. It is not a provision in the Act. You infuse it into your ground being against public policy. I don't think it should be an issue because on purpose, Section 30, which we also know came from on Citral, mentioned misconduct. AMA 233, also on Citral, has mentioned public policy. Not misconduct. But misconduct falls and fits into public policy. So when you use it as a word, it doesn't mean you're making a section in the Act. I stand by that, please.
Okay. Mr. Israel.
I was going to say that maybe you want to look at public policy from the view of uncitral. So if you look at public policy from the view of uncitral, the definition includes misconduct. So
from
basically,
uncitral includes misconduct.
It includes misconduct. So in essence, the couching, whatever the reason is, it still doesn't effectively exclude misconduct. But the policy, the public policy as defined by uncitral in their deliberations is anything that has to do with misbehavior, misconduct, procedural error, fraud, and things like that. So if we go by that definition from uncitral, it's still the same thing as misconduct, which is why I'm saying that the word misconduct being used today is still not against the law, rather it's not out of context of the law, and that the cases that we had on misconduct will still apply today.
Okay. The cases we had on misconduct
will still apply.
Are still relevant and will still apply today. All right, let me take us to, obviously you have mentioned that public policy and may not be open to competent law. Now, our legislation an award arbitral proceeding in court, mean that the award is being. I ask this because, as we have agreed, arbitration is a private process. The question then is, does the public have any interest in an arbitration?
I can answer that from a few perspectives. There's a reason why determination of rights and liabilities is being moved gradually. Is being moved gradually from the courts to private processes. And that also includes mediation. Now, to do that, it's in public interest to have sanctity in the process. Therefore, any private resolution, any conduct which is capable of affecting that process, which the court is entrusting and the law is entrusting in the new process, in the process called arbitration, or even in mediation, excuse me, or in mediation, becomes a matter of public interest, and it's something that the courts will guard against. The second thing is, in arbitration, you still have resort to law and determinations of rights under law. So it's part of public interest that the law is properly interpreted. The last thing you want to do is to see, should I say, decision, I don't want to give the wrong example now, stating the law incorrectly, even on point of contract, or stating the law correctly in regard to the law of the place of arbitration. Usually the courts will intervene, which is why the courts are quick to take an issue like error on the face of the arbitration, and the courts will not ignore any irregularity on the face of law. So it's in public interest that there is integrity in the process.
Let me say this, moderator. If it's public policy that I should not be discriminated against on grounds of sex, religion, or race, it's public policy. And in a private reference I'm involved in, I am now being so discriminated against. Is it private or is it public? I am a member of the public that has made it against public policy for such discriminatory practices. So when it's meted against me by an arbitrator, in the, this is what I mean, I can have that award based on that, because public policy affecting the public space where I'm part of is also privately affecting my interest, and is a ground to vitiate the proceedings and the award is set aside.
One of the fundamental and the very earliest principles is that you take the arbitrator for better, for worse.
No, the arbitrator is coming to act for you under law and rules and regulations. He's not coming in the way he is to act arbitrarily. That's why one of the conditions set aside in the word is when the arbitrator ignores what the law of the subject is a ground set aside. That law is not private, it's public. But it's a ground in section 55 that the arbitrator did not pay attention to the relevant law is a ground to have an award set aside.
So that the notion that the arbitrator, once you go to the arbitrator, you have chosen him, and that you take him or her or whatever he or her gives you. You think that's qualified? Yes?
I just want to add that even the litigation you talked about usually is private dispute. Most litigations are not public disputes. They are not even disputes with government, but the courts still apply public policy.
Yeah, but
so the distinction
managed by a public institution.
Yeah.
The judge is paid by the public funds.
Yeah.
So he's duty bound to act in accordance with the public expectations. But in arbitration, it's a private process where the parties privately pay the arbitrators.
Yeah, but there is no rule that only courts can decide on basis of public policy. The fact that it's a private, one is private and one is paid for by the parties and the other one is paid by public funds does not make any difference. It's resolution of a dispute or the process of resolution of a dispute. But the point also is that even the litigations we're talking about, they are basically a private dispute, just that it's public hearing. But the same application of public policy which has been mandated in the new act is the same thing that the courts will follow.
Mr. Arbitrator, what law is applied in private? That's where I'm trying to base my argument on. The law applied in my private dispute by an arbitrator is the public law.
The law is chosen by you.
No, we choose the law of the seat.
But not law made by the parties.
Not law made for me.
So your view is that despite being a private process, an arbitral proceeding an arbitrator is still enjoined to observe fundamental notions of justice and principles of law.
Yeah, but
yes.
If I may
the
just...
public policy is in the law now. It's there that it should apply if it goes against public policy. They know that this dispute is private, but the AMA simply says public policy.
There are many facets of public policy. One of them is if it sends the wrong message. Right? So even if it's a private matter, but if it sends the wrong message, this. I'll give the example of some of the decisions on wills, which is private law. And the courts are saying, no, this will is against public policy. It's a personal property, but you are saying your wife cannot, the widow cannot inherit, or women cannot inherit, or women cannot own properties. These are private matters arising from wills, but public policy will not allow it. So the fact that it's a private matter, or it arose from private proceedings, even if it's a will, even if it's not dispute resolution, does not change the nature and the effect of public policy on that particular issue.
Let me add this to this, something that we catch, what you just said about wills. There's a case I read once where a will was, the court set aside the provision against the wife. The man put a bequest for the last wife and said, to my wife so until she remarries. And the court found that that provision was against public policy. Because it restrained the woman from remarrying after the man had died, and she was a young woman of less than 35 years. But the man put it there that she would stay in that big house in Victoria Land until she remarries. The court found that it was against public policy, and the will was not, yes.
I'll just give one small example from arbitration also. If an arbitrator in the course of proceedings says something to the effect of, or has the effects of denying one party the opportunity of cross-examining the other party or a witness, should the court close its eyes to it? Is it a matter of public policy that the court cannot close its eyes to? So even though it's private proceedings, but it's something that the court cannot close its eyes to because of the integrity of the process.
Okay, one last question finally, and then we can wrap up this. And I'll start with you, Dr. Kovundo. Do you think that despite the provisions of the new AMA, an award may may still be set aside on ground of misconduct.
Like I've said, I'm being repetitive now. I said, if the word is your problem, you can go to the teacher and take another word for it. It will fit into under public policy. Because misconduct on the word does not stand on its own. There are what you call areas of misconduct. It's like you itemize them, there are particulars of misconduct. And those particulars will fit into public policy, and you go for setting aside.
Mr. Usman.
Yeah, the word misconduct is, excuse me, is a generic word. I think even if you don't use the word misconduct, if certain situations are brought to the attention of the court or serves as foundation for a claim to set aside, for example, what the court is looking at is the circumstances, whether you call it misconduct or not. Those principles will still apply. Anything that the court will not close its eyes to, procedural error, even breaching the arbitration clause is misconduct. If you don't follow the mandate given to you in the arbitration agreement, it's misconduct. And the court can set aside for breach of the arbitration clause. So for me, the word misconduct is not important. As he said, you can use another word, but I also think that if you use the word misconduct, it doesn't change the fundamentals of the case. What the court is looking at is not the word misconduct, but the circumstances, the facts that are brought to its attention, that is brought to the attention of the court, and whether or not the court thinks it sort of affects the award or the law or the procedure.
Right. So in your own view, we took quite a number of time before we amended the ACA in 2023. Do you think that the MA has any need for an amendment to bring it in full compliance with the UNCITRAL provisions, particularly with respect to issues of misconduct and setting aside? Mr. Usman.
In the circumstances, yes, it does, and also on some other issues. I'll probably give the example of why we need an amendment. In 2020, when we had the newcomer, what the newcomer did was to help clarify certain fluid situations. The issues about what the debenture is, the issues about who a director is. So what KAMA did was to help resolve some of those issues that may lead to guesswork, and also sort of leave the courts guessing as to what the answer is. So if at any point it becomes obvious that the removal of the word misconduct is going to cause problems and is going to affect the integrity of arbitration, I would suggest an amendment.
Like I said, the law is dynamic, and no law comes out to address everything. And like you also pointed out, the time it took for the amendment left a lot of things not captured in the new act. I can see us being vibrant enough to have it change maybe within the next 5 years.
Oh, 5 years.
Yes.
All right, thank you very much for your very useful contributions. I don't know whether we have any comment or observation or question from any person in the audience. Anybody who wants to ask a question, or do we have from those who are joining us virtually?
Yes,
Anybody
I think there are comments online, but I don't know if anyone wants to make a comment, then we give them the opportunity.
You just say your name and then you can make a comment.
Ask question or make a comment.
While we're waiting for that, can we have the online comments?
Okay.
And I will ask the moderator to read our secretary to read out the comments we have online.
All
right. Read the comments we have online.
Okay. Or let him be taking his question while.
Okay. Okay. Just introduce yourself and then.
Abdullahi Haruna. I have listened to the comments very carefully, and I want to speak on the issue of misconduct. Will you say, or I want to ask, will you say that given all the effort that went into amending or the new AMA and removing misconduct as a ground, will you say that all that effort is in vain, looking at the expansion we are giving to the definition of public policy? Or will you say that misconduct, for instance, has become a fact under public policy and still exists?
Who did you address the question to?
Any of them, yeah.
Dr. Komodo, please.
Sir, if you listen, you were listening to all I said. I don't think it was in vain. All I said was that I'm not aware of the mischief that was sought to be resolved. But by whatever they did, they put in a phrase now that encompasses more than we had before. So it wasn't in vain. They've given us more to deal with than we had before. That was my point.
Thank you. Usman, do you have anything?
I'll just say that the word public policy within the context of ancestral provisions is a stronger word than misconduct.
Thank you.
So I think we're in a better place, actually.
Thank you. Yes? Any more comments, or do we have the online comments now to take the online comments?
All right, so we have a comment from Mrs. Ojoma Izora, and she has said, but it was our members that proposed the law which was passed. My thinking was that they tried to reflect the state of the art version by which the narrow misconduct provision was seen as nebulous, as it all sorts of claims come under it. Public policy appears more tidy. Public policy was always in the laws anyway. My thoughts.
Any other one?
Yes, she has also said that the public is interested in the outcome of private dispute resolution. Once resolved, the state apparatus has done that which should be done. It's also why the court will not disturb the outcome except on the basis of public policy. That's all.
Thank you. Do we have any other comments, observations, or questions on the topic that has been discussed? Well, gentlemen, I want to thank the two distinguished panelists, and I want to thank all of us who have listened to their discussions. And I think that what has happened is that the discussion today has indeed served its intended purpose. Purpose was to begin to elicit in our minds the need for a wider and more inclusive discussion on this issue of setting aside of an award on ground of public policy. What are the limits of public policy, and to what extent has this amendment affected the case law that existed on the subject? And I believe that this would form part of what will be in our future lectures or seminar series. But I thank all of us who have attended, and I want to wish all of us a very Merry Christmas and a prosperous New Year in advance. Dr. Kobondo and Mr. Israel Usman, thank you for your time, and we look forward to inviting you again. And if we do invite again, you will find time to also give your full attention as you've done today. Thank you very much, and God bless you all.
Thanks for having me.
Thank you. I think they deserve more applause, yes. Because, like I have mentioned earlier, value for time and quality is what you always get in our seminar series. And I encourage everyone to keep tuning in for this seminar series. Thank you all for such a wonderful and insightful discussions on this very important topic. And thank you to the participants and for your contributions. As we have heard from the panelists, there is generally the need for people who act as arbitrators to uphold the standards of excellence and integrity to protect the arbitration process. Thank you very much, and I invite you to clap once more for the panel and for yourselves. With this, I invite the college president to give us a closing address. All right. Okay, the chairman of the. Okay, I beg your pardon. Sorry.
No problem. I thank the college president. I thank the participants. In fact, first of all, tender my unreserved as the president, the vice president, Dr. Akobondu, and Mr. Osman, as we are all aware, that classroom. Because today we are trying to recruit more teachers, and we have to interview. I was thinking there were only 3, and the interview was fixed for 9 a.m. Fortunately, interviewing 11 candidates, not only for Faculty of Law, but for other faculties in the university. This accounts for my coming in late. I should be the one to come here and prepare the hall. So I'm the one that is to thank everyone. And those who have accepted, I don't want to use the military language, as I will compel some, and they gladly accepted the compulsion. And some that we've approached who are well intended, because we make it an in-house factor. The reliable hands in the house, and that has just been exhibited now. I thank everyone that is physically present here, and Chioma, I must confess I miss a lot. This is the second assignment, but the first one, I really appreciate your input. I know FIDA held you back because we really at that time in point. But thank God that it is a reality. It's not the number of people are in attendance that matters, but the number of the quality of what we are taking home. I indeed and sincerely appreciate the president. Even he has no time. I will call you. I will call you. At the end of the day, the call will not come. So, but he really put his mind in it, and he put his materials, financially and otherwise. We owe you a great gratitude, sir. My profound gratitude goes to Dr. Akobondu, the first person that we sought for and got. But for our Mr. Osman, who is fully loaded, and always saying that, don't call me, I won't speak outside. It's good. The college is established to come and make good the practice of arbitration in the country. So no law that is permanent. There's room for amendments. We have recognized that this, even though I came late, the public policy as provided under the UNCITRA rule is all-embracing, all-encompassing. So we don't want to read the mind of anybody or the intent of any lawmakers. You know, even judges cannot even review any law. They cannot change it. Whether a law is their duty, fundamental assignment is to administer the law. So, Mr. Osman, we shall still be knocking at your door. We're calling you time with that number. You are our own property. So the college has declared it that we own you, sir. So I thank Mrs. Combo as well. Mrs. Combo, we thought before all our input on the platform, she's a guru in arbitration. Even though she's not yet FC. She's a guru in arbitrator. Look at me, I'm just an associate in the CI Hub. I've conducted over 10 matters in arbitration, translating to 10 awards. One of it, I was the chairman of the tribunal. Not because you must be a fellow before you can bring yourself out in arbitration. My thanks goes to her because she has been representing the college also. She just returned from Jos, and while her husband was telling her, you want to give yourself rest? I told her that you have a doctor in the house. The gentleman can massage you, then you come and take up this assignment also. she politely turned it down.
Recording in progress.
And for her being in our midst today, I thank you very much. The ladies and gentlemen, I thank Chief Okolo as well. Yes, a man I can never forget. I'm seeing in our function for the first time. I hope you will be coming, and I hope you'll be part of us. You are welcome. Thank you very much for coming. So the president make this a reality. I must call on him to give a closing address. You are welcome, sir. The president. I say, Your Excellency, sometimes.
No, it's not me. Well, I like to stand on the protocols already very well established. But let me thank everyone who is here present. But let me thank particularly the people I'm seeing here for the first time in our event. And I recognize my brother, Mr. Ibrahim Haruna, SN, Chief P. Okolo, SN. And then I want to appreciate all of us, members and our friends who have come. Despite the very busy schedule we all must have, knowing that this is end of the year. But what we set out to do in this college is to deal with not really academic, but to deal with intellectual issues relating to the practice and profession of arbitration. And we hope that we'll continue to emphasize excellence, emphasize knowledge, emphasize integrity in the arbitral process. But I thank all of us who have come, and I want to ask that God Almighty will take all of us. Said that we have prepared today to have not just discussion intellectually, we also have room for social interaction. So I will invite you, when you turn to the back of the hall, to please yourself with what you have provided, and then you can take as much as you want, and you can also take to go home, or take away, or take home. So thank you all a very enjoyable holidays and a very prosperous 2025. God bless you all. Thank you very much.
Nigeria, we hail thee, our own dear native land. Though tribe and tongue may differ, in brotherhood we stand. Nigeria, home and proud to serve our sovereign motherland. Our flag shall be a symbol that truth and justice reign.